Hi, everyone. Thanks so much for logging on. We're very psyched to have you here. My name is Pat Garofalo, and I'm the Director of State and Local Policy at the American Economic Liberties Project. We have a great program for you today, looking at how states can rein in utility profiteering. In recent decades, monopoly utilities have gamed, captured, and made a mockery of the regulatory process that's supposed to keep them in check, enabling them to extract excessive profits from the public. Since 2020, monopoly utilities have increased residential electricity rates 49% above the rate of inflation. Electric and gas utilities last year requested a record-setting amount of rate increases at 18.1 billion, marking the third consecutive year in which a new record was set. In some areas, utility rates have tripled over the last decade. Now, these rate increases are not some immutable fact of the economy or the market, but are policy choices. And state lawmakers and advocates across the country are fighting back, working on new laws to rein in monopoly utilities and lower costs for consumers. To help them out, we've released a toolkit for state legislators that includes several concrete steps they can take to protect their constituents from unfair utility profiteering. Now, we're hoping to have Arizona State Senator Priya Sundareshan speak with you all today, but her schedule has gotten a little bit complicated. So we're actually going to start with a key idea in that toolkit and in a standalone paper that we released at AELP, which includes perhaps the ticket to lowering rates for consumers. So it is my great honor to introduce first Megan Robertson, our utilities organizer here at AELP, and Mark Ellis, our senior fellow for utilities. Turning it over to you two.
Great. Thanks very much, Pat. And I will actually hand it over to Mark, who is the expert on rate of return to talk through some of these complicated ideas that can really save folks a lot of money.
Sure. Thank you, Pat and Megan. So as Pat mentioned, AELP recently published a paper that I wrote about called Rate of Return equals Cost of Capital, a simple, fair formula to stop investor-owned utilities from overcharging the public. A bit about my background. I am a long-term utility insider. I've been in the industry for 30 years, 15 of which I was the chief of corporate strategy and chief economist for Sempra Energy, one of the largest utilities in the country. So I have a very much an insider's perspective on utility finance and how utilities have gamed the system as Pat described. So what the paper does is it exposes one of the critical elements of utility rate making, which is the rate of return or the profit that utilities are allowed to pass through to customers in their rates. And the paper basically goes over 5 different topics. First, it gives an overview of the utility rate making process, and it explains exactly how the rate of return impacts and the contribution of the rate of return to customer rates. It accounts for about a quarter of the total customer rate. The utility profit is 1/4 of your utility bill. Then it talks about the longstanding Supreme Court standard for determining an appropriate level of profit. And it's basically the rate of return should equal the cost of capital, which is the market-based cost of capital or the return that investors would require to invest in another investment of comparable risk to the utility. And then I present evidence that the rate of return that regulators have been authorizing for decades has far exceeded the actual market-based cost of capital, and that the cost of that is about $50 billion per year nationwide, and which works out to about $300 per household, per residential household. Then I present, various sets of evidence about, how we know that in fact the rate of return is so much higher than the cost of capital, and also that this is not a new phenomenon. It's been known for 50 years. How to assess whether the rate of return is too high. And the evidence shows that for the last 30 years, it has been dramatically higher than utilities' cost of capital. And then the last 2 sections describe how we got here. And basically, it's a story of regulatory capture where the utilities have had excessive influence over the decisions that, not just the decisions that regulators make, but the entire rate-making process, down to training of the experts that the utility consumer advocates hire. The utilities actually provide the training for those experts. And then the paper closes with a list of recommendations about things that can be done to change this. And I'm pleased to see that some of these actions have already been started, are already underway. So one of the recommendations is to actually pass legislation to codify this rate of return equals cost of capital standard, and to make sure that it actually equals the market-based cost of equity. And I noticed that there are bills in a number of states. Even just yesterday, New Jersey announced one. So it's very pleasing to me, personally gratifying to see that states are starting to take action. People are starting to recognize the problem of excessive rates of return. And with that, I'll turn it back to Megan.
Great. Thanks, Mark. And we do have a couple of questions. And folks, if you're interested in asking questions, you can ask in the chat to get more detail here. But a couple of questions that have come up already. If rates of return are already supposed to be equal to cost of capital because of legal precedent, can you expand on why legislation would make a difference here?
So there currently isn't legislation. It's based on Supreme Court precedents. So there's a number of Supreme Court precedents that have established this. Probably the most prominent is called FPC versus Hope Natural Gas from 1944. And that essentially put a stake in the ground. But everybody agrees, both utilities and regulators agree that the proper interpretation of Hope is that the rate of return should be equal to the cost of capital. I think it's partly the one element of the bills that are being under consideration is that instead of the way the rate of return is currently set is the utility comes in and says, I think my rate of return should be X, and they set an anchor, and then everybody negotiates around that. So some of the bills under consideration, New York in particular, says, no, we're going to take it out of the utilities' hands, we're going to codify it, and we're going to put it in the commission's hand or the PSC's hands, and then that becomes the anchor. So that's one element that's not currently in legislation. But I think the issue is that regulators have not taken this issue very seriously. And so this is a way to tell them that, no, this is actually very important. If you were to review the proceedings in a rate of return, and even in the paper, I talk about how one regulator dismissed the rate of return as eye candy. So they just don't take it seriously. So I think this would be a way to encourage them or even force them to start to take it seriously.
That makes a lot of sense. And what will the effect for consumers be if you are able to get the rate of return locked in this way?
Yeah. So there's two general effects from the rate of return. So one is an immediate reduction in rates. This is probably the only lever that regulators have at their disposal to affect an immediate reduction in rates. And ballpark figure is that if you set the rate of return equal to the cost of capital, it will result in an immediate 10% reduction in rates, both for gas and electric on average. Obviously, it will vary by customer class and utility, but about 10%. So that works out to, as I said, about $50 billion a year nationwide in customer savings, $300 for the typical household. As or even more importantly, it will bend the curve of future rate increases. So the issue of the rate of return being higher than the cost of capital isn't just, oh, their profits are too high. What it does is it creates a tremendously powerful incentive for utilities to invest as much as possible. In fact, one commissioner in California recently said that the excessive rates of return makes it the utility executive's fiduciary duty to invest as much as possible. Which is interesting. It's a concession from a regulator herself. And so what that causes is they just want to invest as much as possible. And that's a key contributor to why we've seen such skyrocketing rates over the last few years is utilities just want to invest. And this sort of pulls the rug out from under them in terms of their financial incentive to overinvest in that way. And one of the points I draw out in the paper is that when you compare investor-owned utilities who provide about 70% of the electricity and almost all the natural gas in the country to publicly owned utilities, they haven't had the same type of rate increases over the last few years at all. So they're able to invest and keep the lights on and even decarbonize, but still keep rate increases dramatically lower than the investor-owned utilities.
So for those of you sitting and listening to this and hearing from folks in your state that their electricity rates are skyrocketing, this is a great opportunity to actually do something about it and try to push things forward in a better direction for folks. Mark, are there examples of places that have passed rate of return legislation and has been really successful?
I'm not aware of it being codified anywhere. The New York bill, I think, was introduced in 2023, and that's the first that I had ever seen it. It hasn't been passed. So no, I'm not aware of any place where it has been passed.
So it sounds like somebody has a chance to be groundbreaking
Oh
and
yeah,
really make a huge
yeah,
impact for folks in their states and their communities.
yeah. I mean, it looks like a number of states are looking at this. So and it is bipartisan. So there's in Florida, it was introduced by a Republican. In the other states by Democrats, but there's a lot of it. Everybody wants a lower utility bill. Everybody's suffering. I've been looking a little bit at the Census Bureau collects data on energy insecurity, and it's really quite tragic. 1/3 of U.S. households answered yes to the question in the past year, has your household had to forego basic necessities like food or medicine in order to pay a utility bill? 1/3 of all U.S. households, all income levels, all age groups. That's when they talk about the affordability crisis, there's grounds to call it a utility affordability crisis. That's a real problem.
Thanks for that, Mark. And for those of you who are wondering how you might get more information on this, you can definitely check out our website and look at the toolkit. And then also reach out to me, and I'm happy to help you as you kind of navigate through these processes to try to author legislation in your state. With that, I will pass it back to Pat.
Thank you so much to Mark. We're so lucky to have him on the team. Now to explain some other steps that state legislators can take in addition to locking in the rate of return, like Mark suggested, I want to bring up first Matt Casper, Deputy Director of the Energy and Policy Institute, great friend of AELP, and Kainoa Lohman, research analyst here on our team, to talk through a few of the other things, again, like I said, that states can do to address the monopoly utilities' cost, their influence over the political process, their ability to disconnect people from utilities for in certain instances. So there are a lot of really great things that state legislators can do to step up and address the monopoly utility problem. With that, I'm going to turn it over to Megan to talk to Matt and Kainoa.
Thanks so much, Pat. And Matt, it would be really great to hear from you and hear your amazing perspective here about money in politics and how some of the funding that comes through from utilities is impacting our politics and impacting really everything around utility regulation.
Great. Well, thanks to AELP for releasing this toolkit, and Pat and the team. I think this, of course, comes at a really important time to tackle what Mark talked about as the utility affordability crisis. So, yeah, I want to talk about utility accountability bills, which is our shorthand way of calling all the legislation that's been introduced and passed in a few states to prevent monopoly utility companies charging their captured customers for political activities and advocacy expenses. These are often activities that harm consumers, including advocacy activities at all levels of government, fighting policies to protect customers or introduce renewable or climate policies as well, along with all the expenses tied to advocating for higher rates at public utility commissions, the costs for new power plants, and arguing for that higher ROE that Mark touched on. This type of legislation also prevents utilities from spending customer money on image building advertising, public relations campaigns, funding trade associations and nonprofits that advance the utilities' messaging and legislative goals. Also, other unnecessary items like private aircraft, gifts, entertainment costs for the executives, board of directors, and other employees. Most utilities, of course, are technically prohibited from passing the costs of lobbying onto customers. But I think the American Gas Association, which is the trade association that represents monopoly gas utilities in the country, encapsulated the problem perfectly when they told the Federal Energy Regulatory Commission a few years ago, quote, "While lobbying is a form of advocacy, not all advocacy is lobbying." So in other words, this monopoly utility trade group itself is acknowledging this wide swath of advocacy not getting treated as lobbying and therefore charged to shareholders and not customers. And so at EPI, we have several reports that dive into this issue, highlight dozens and dozens of examples. Some of my favorites include when we see utility companies want to recover the cost for the suite or the luxury box at baseball stadiums, promotional advertisements. I think I recall one utility in Florida wanting to recover costs for a manatee exhibit in Florida. So just really unnecessary costs that doesn't do anything to help keep the lights on or our homes heated. Now, commission staff, attorney general offices, statutory consumer advocates, they all do an amazing job arguing that these costs should be out of rates. But as you can imagine, these are massive rate cases, multi-year rate cases, and these staffers are also likely working on they're in other dockets, arguing in other rate cases, all simultaneously. So the solution here, we think, is pretty common sense. Pass legislation that details what cannot be recovered from customers and put transparency and enforcement mechanisms in place. And when we talked about this several years ago, we of course knew that there would be savings, that the regulators would be able to cite laws and prevent costs from being charged to customers. And now that some states have passed this type of legislation, we can point to the laws on the books in Connecticut and Colorado as actually saving customers money. So after the bill took effect in 2023 in Connecticut, a gas utility comes in for a rate case, the law's on the books, and the regulators there are able to strip over $600,000 out of the rate case expenses. In Colorado, similarly, a gas utility comes in for a rate case once this is on the books, over $700,000 is now stripped out of the cost in that revenue requirement. So real savings for customers when these policies are in place, and a lot of active legislation right now. Maryland Delegate Andre Johnson has this legislation scheduled for a hearing tomorrow, HB 960.
Thanks for that, Matt. And that is really impactful. Curious if you can shed light on how the states that have passed some of these laws have put together the coalition and kind of built the political will to make it happen. I would guess there was quite a bit of fierce opposition from utilities.
Well, yes, typically it is the utilities wanting to prevent this type of policy from happening, which I think speaks volumes. You might hear that the utilities will say this is duplicative, unnecessary. We don't charge customers for this. And well, okay, show us the book a little bit more, then you'll have no problem, having us pass a bill that codifies what you are saying. You're not charging the customers? We'll codify it. But no, a lot of coalitions have formed. I referenced Maryland. It's not just environmental groups. You have AARP and other consumer advocates banding together because they know the importance of having this type of policy in place. In Maine, it was passed with bipartisan votes. And when this issue has popped up at FERC, it's again not just environmentalists asking FERC to take a look at this problem, but it's like I said, offices of attorneys general, even large energy users, refineries, paper mills. These folks don't want to be charged for the utilities' advocacy expenses.
Absolutely. And then in states that have passed these laws to restrict the use of ratepayer money on politics, how effective has it been in kind of reining in the utilities' political power? Are they finding other ways to influence legislation outside of, the lobbying and advocacy that you've discussed when they are cut off from the political dollars?
Yeah, I would just note that this type of bill, these laws, that is their First Amendment right, of course. They can practice that type of political speech, and these bills doesn't infringe on that. They just have to use the money, the profit, um, to continue to make political contributions, to go and lobby. But you bring up a good point on the transparency part of things. So in Colorado, the regulators there were able to see that utility was not excluding all of its lobbyists, all the staff that it has in doing these political activities, doing the lobbying. They only were excluding the registered lobbyists from rates, but state lawmakers, commissioners, they all know there are many other folks at the utility companies that technically aren't registered lobbyists, but do political activities, and customers are paying for their compensation. And so these policies help get all of those other costs out of rates too. And I think we'll see more of that type of effect happen.
Great. Thanks so much for that, Matt. And just a reminder to the folks listening in, if you do have questions, feel free to drop those into the chat and we will make sure to ask our experts. Now we'd like to talk to Keynote a little bit about mergers and corporate power. So I will pass it over to you.
Thanks, Megan. Appreciate it. My name is Kainoa Lohman. As Pat mentioned, I'm an associate here at Economic Liberties. I got to help out a little bit with our toolkit, and I'm going to run through a couple items from the toolkit, just really rapid fire here. The first one is to remove barriers to solar adoption. So, rooftop solar is obviously a very popular way that consumers can empower themselves to reduce their electrical bills, either by consuming some of the energy themselves or selling it back into the grid. And for that very reason, utilities don't like it. They view it as competition that threatens their bottom line. And they have employed various tactics in different states to try to impede customers from installing and using their own solar. So there's a couple things you can do here. One baseline reform is just to not allow utilities to levy anti-competitive fees on solar owners, which is something that they have tried to do in a few different states. Another thing you can do is to legalize third-party solar financing. So some solar providers will offer a model where they will install themselves a solar system that they own on a customer's home, and then they'll sell them the energy or lease them the system. This model has a number of benefits. It, can eliminate the sort of prohibitive upfront costs that might discourage a lot of residents from trying to install solar themselves. It also turns a pretty daunting home improvement project into a service. It's something that has been legalized to some extent in a majority of states, but utilities have opposed it. Obviously, they've funded ballot measures to ban it in certain states. And so you can kind of check the status. We provide some resources in our toolkit to check the status of your state and make sure yours is one where this model is allowed and encouraged. A last thing you can think about doing is initiating a public leasing program. There are some states like Connecticut, which have experimented with programs such as these for solar that have successfully boosted adoption, especially for lower and middle income residents. So that's solar promotion. A second thing in our toolkit that I'm going to talk about briefly is blocking large utility mergers. So like a lot of industries, there's been pretty massive consolidation over the last few decades in the utility sector. From 1995 to 2012, the number of monopoly utilities fell by more than half due to mergers. Today, investor-owned utilities are just 6% of all utilities out there, but they provide electricity to 70% of Americans. And the result of that is basically they've become in a lot of ways too big to manage. They have amassed political power and spent a lot of money doing the bad things that Matt Casper talked about a little bit, essentially, paving the way for themselves to raise rates and undermine the public interest. So we would recommend sort of a two-pronged approach to dealing with this consolidation problem. The first is pretty simple. States should implement a ban on utility mergers above a certain size threshold. You can determine this threshold based on market share, revenue, the customer base. But we would recommend having, the Office of the Attorney General develop some sort of public interest framework on determining what mergers of what size would fall above that threshold. Um, Second thing you can do here is craft merger guidelines, ensuring that mergers that do fall below that size threshold would meet certain public interest requirements. So this is sort of an approach to merger policy that some states have pioneered in healthcare. So Minnesota a couple years ago adopted some guidelines governing hospital mergers. Mergers below a certain size would be evaluated by a set of criteria, whether that's reducing access to care, negatively affecting wages or collective bargaining agreements for workers in the hospital systems, but basically gives you a more comprehensive and thoughtful format for policing mergers for a service that we all rely on. And yeah, those are the two that I was going to go through. So I'll hand it back over to you, Megan.
Thanks, Kainoa. I'm actually going to jump in because we have the senator here. It is my great honor to introduce Arizona State Senator Priya Sundareshan. Senator Sundareshan represents Arizona's 18th Senate District, is the leader of the Arizona Senate Democratic Caucus, and has been working for years to hold monopoly utilities accountable, and in particular to reduce their power and influence over the political process. She's setting a fantastic example for other state legislators to follow. We're very lucky to have her here today. Senator, over to you. Oh, I think we may be having Wi-Fi issues with the senator. I think we'll give the senator a moment to sort out the internet in Arizona. Megan, can I toss it back to you? Oh, no, I think we have the senator again. All right.
I'm so sorry. My internet chose this moment to say that it was unstable, but I'm here.
We're very happy you're here. Thank you, Senator. I'm going to turn it over to you.
Sure. Well, thank you so much. And I'm sorry I missed the first half of the conversation because of time differences. But I'm sure it was really informative, and I will go back and take a look because I think we're going to have some really important steps to take in holding utilities accountable. I'll just, like I said, like Pat said, I'm the state senator in Arizona. Before that, I was an environmental lawyer with a keen interest in trying to do something on climate change. And part of that is the recognition that utility decision making has so much power, but that they also have a lot of influence with the money that is spent on who regulates them and how, and therefore the requirements that they're and the various standards that they're held to. So when I came into the Arizona Senate, now this is my third session, so that would be in early 2023. I came upon a tweet from Energy and Policy Institute talking about ways that we could try, ways in which and bills specifically at the state legislative level that might help to decrease the role that money plays in preventing utilities from taking those proactive steps forward. And so based on that, I put together a bill, and we're refining it over time. But the bill that I introduced to prohibit the ratepayer money being used on lobbying purposes and association dues, all of the things that have directly been responsible for either stopping action to take more progressive action or require more progressive action by utilities, or the association dues that have helped fuel misinformation about climate change for all of these decades. Those are all tied to that. And so to be able to say that ratepayer money should not be used for those purposes felt like a really important thing to do. I introduced that bill in 2023. I have introduced it every single year. I'll talk more a little bit about the lay of the land, but I am in the minority in the Arizona Senate, and so my bill has never gotten a hearing, unfortunately. But but there has been a lot of interest from community about it, and so that's really exciting. The other thing about Arizona is that we have our utility regulator as the Arizona Corporation Commission, and it has a unique role among regulators in other states because the Arizona Corporation Commission is actually kind of a constitutional body. It was created when Arizona became a state, and so it has its own section in the Arizona Constitution defining certain roles that the Arizona Corporation Commission is responsible for, which has led to some questions sometimes about what can the legislature do in advocating for what ratepayer monies can be used for, and what is solely within the authority of the Arizona Corporation Commission. There have been lawsuits, there have been that have tried to delineate that, but a lot of it is still untested. Where we are also is that we had a renewable portfolio standard that the Corporation Commission, when our now Attorney General Chris Mays was a Corporation Commissioner, put in place. It was a pretty modest renewable portfolio standard put together in the early 2000s that I believe was something like 15% by 2025. And unfortunately, and that was easily met by our utilities. And then in recent years, there were efforts to try to update that renewable portfolio standard, and they were stopped at the Corporation Commission. And since then, the Corporation Commission has gone from having 3 Republicans to 2 Democrats elected to be on the regulators. Currently, we are at 5 Republicans, no Democrats, and the direction of the entire body has been to essentially rubber stamp any rate increases that utilities seek, to allow utilities to start putting additional charges on people trying to interconnect with solar panels. It's just very difficult for progress to be made. And so that's where I see an increased need for the legislature to come in and to take a more aggressive role and maybe test out what are those constitutional delineations. So in the renewable portfolio standard space, I had for the last 2 years also introduced a memorial, which is kind of a postcard to the Corporation Commission, encouraging them to take up the renewable portfolio standards that they had considered updating and making stronger, and then ultimately kind of put to the side. And I, for the last 2 years, said, Corporation Commission, please reconsider that. You spent a lot of time and effort on that process. I would love it, please take a look. Climate change isn't going away. And this year, given the new environment of the Corporation Commission, I turned it into a bill itself, a straight up, here's what the renewable portfolio standard for the state of Arizona needs to be. And, again, that bill did not get a hearing, but going back to the broader community support, there are environmental organizations that are, gathering grassroots support for both having a higher renewable portfolio standard and also around the bill to prohibit ratepayer money being used for association dues. And so what we've done the last 2 years is they have come with me. We've had a gathering of supporters to come with me as I've walked the bills over and introduced them into the hopper both years. And I think that's been really exciting, both for me and hopefully for the community, so that they know that they have champions who are trying to continue this conversation and to make sure that when we are in a space, when Arizona is in a space to be able to move these bills forward, that we're ready to do so. And I could stop there and turn it over for the questions that I think our folks are putting in.
Absolutely, yeah. If you don't mind, I have a quick one. Given the reality today of high costs, the political salience of affordability, are you feeling any better about any of this work today versus a couple of years ago when you started in the legislature?
Somewhat. I mean, yes, I think that salience is absolutely even more real and relevant. But the climate change salience has always been relevant, and even more so now. In Arizona, we've been having 80-degree days even in January and February this year, and that is not right. That has been pretty scary, and of course, a very dry winter. And so all of these things just continue the importance of us to be able to focus on these issues. And then, yeah, affordability just as an extra component is important, but unfortunately they don't seem to, they're not getting past the first hurdle, which is getting a hearing and being able to have that committee process. And I will also add, I guess part of the other lay of the land is instead this year the utilities are actually running multiple bills to insulate themselves even further from any kind of oversight or liability. So there's one bill going through right now that is seeking to, under cover of the utilities saying, we're going to put together a wildfire protection plan, which everybody loves. We all agree wildfire mitigation and protection is very important. And in fact, they're doing that anyway. But in exchange, the other part of that bill is, and by the way, we're also not going to have any sort of liability for damages that result from a fire. There's a couple of other bills the utilities are running to further reduce their liabilities or reduce any costs and increase their own personal profits. So that's the challenges we face right now.
So are there parts of a coalition that are missing today that you really wish would hop in? And I ask this question because in some places you sort of get a strange bedfellow situation, right? Like you get big box stores who really care about their utility bills, but aren't necessarily traditional progressive allies, but want to work on things like this. So who's missing in Arizona that should be engaged?
That's a great question. I think that's exactly who we're missing in Arizona. Right now, the opposition to a lot of utility proposals. The liability one, we've got the insurance industry has come in to oppose, so that's helpful. On the other topics, or even on the proactive, how do we reduce these bills? How do we, on my bill to reduce the, ratepayer money being used for these purposes? I would love to see much more of that kind of business community approach. Because right now, it's the environmental groups are really the only ones who will chime in and say we need some action on climate change, and here's how. It would be great if some folks would raise their hand and take on the utilities.
Awesome. Well, thank you so much for your time, Senator. We're so lucky to have you here today. Keep doing everything you're doing. Please let us know what you need from us while you're working on it. And I'm going to turn it back to Megan and the team to go through the last bunch of questions that we have had coming in through the chat. And just keep them coming, folks, if you have them.
Absolutely. Thanks for that, Pat. And while we're watching for questions to come through, I'm going to talk a little bit about right of first refusal, which many call ROFR. So what does it stand for? Right of first refusal, essentially meaning that your utilities that are in the state, the monopoly utilities, not only have this monopoly on being able to provide electricity, but also gives them a monopoly on building out the electric grid. And the way that it works at the federal level, they've actually passed a rule saying that right of first refusal is not a policy the federal government recognizes. But in lots of states, we're seeing this legislation pop up. My home state of Indiana passed it actually a couple years ago. 11 other states have passed it. And there's a ton of legislation going through right now, actually, in the states. Wisconsin is one. We've seen it in a lot of different states. Why does this matter, right? Why does it matter who builds out the grid? Well, one, hundreds of millions, billions of dollars actually are going to be spent on this, especially as we're looking going forward over the next 5-10 years, as we know that there's going to be more need for power, and we need to upgrade our transmission to be able to move that power more efficiently. So why is it bad, though, that your utility would be that the local utilities have this advantage and the right of first refusal to be able to build this out? One, reduce competition, right? It essentially says that the utilities in the state can build this out and they're going to make a bid, and that's what we're going to go with. You're not going to have people competing with lower prices to be able to get this business. A 2019 study shows that 20 to 30% savings come when you actually have competition for this work and have folks putting bids out. The other thing that's interesting about this, it might be helpful in some of your states as you are seeing this legislation pop up, is that actually the federal and state courts have been ruling that this type of activity violates what's called the Dormant Commerce Clause, essentially saying that these policies, where they are passed, are discriminating against states that or against businesses that happen to be located out of the state. So again, just kind of want to raise this as an issue for folks to be looking at. It's an opportunity to keep prices low for consumers as we are kind of going through this massive transition and trying to get the grid modernized. That we've got to have competition and try to get the best deal for everybody to make sure that we're keeping these rates as low as possible for folks. So with that, just a reminder, keep putting the questions in the chat and we will get to them. I do have one question for Mark here, asking if you can explain a little bit more about how utilities are providing training to consumer advocates.
Sure. So the way the rate of return is set is each party. So the utilities actually generally don't use internal experts. They don't pull people from their finance group. They hire third-party consultants. And there's basically 4 firms that provide almost all the rate of return expert witness testimony in the entire country. 2 people provide about half of it. These people tend to be very well credentialed. You see a lot of, Wharton PhD type folks. But for what the utilities did a couple decades ago, they set up an organization called the Society of Utility Regulatory Financial Analysts, SURFA. And basically they conduct a 2-day workshop for consumer advocate and intervener experts to learn how to do rate of return, but according to the utilities playbook, and to demonstrate how sort of corrupt the utility playbook is. In the SURFA training manual, they talk about a model they use to calculate the rate of return. And they say, this is the granddaddy of all rate of return models. And then on the very next page, they say, we can't square it with economic theory. So they admit that it's completely bogus, but this is a model that they promulgated across the entire industry. So not only do the utility experts use it, but many, if not most, consumer advocate experts still use this model. Incidentally, the FERC did a review of the various models used to calculate the rate of return in regulatory proceedings, and they barred the use of this model. They said it has been thoroughly discredited and defies general financial logic. Nonetheless, many state advocates are still using this model. So this is an interesting element, how the utilities have essentially co-opted the entire process. They hire their, Wharton PhDs, but, send a staff analyst to a 2-day training and they're all set. So it's a real problem, a huge asymmetry of resources and expertise.
Thanks for that, Mark. And then another question that came through the chat. And I think this is a question for Mark, but also really kind of for anybody who wants to speak up on this issue. And obviously, I think the senator could answer this too. But what would you say to state legislators who are more comfortable leaving this kind of rulemaking to independent regulators? Is legislation really necessary? And I think this was more regarding rate of return, but I think it kind of applies to a lot of the things we're talking about here. Why do we need to do this?
I'm happy to field it, but I'll defer to the senator.
I guess, from my perspective, we can't just, in Arizona, we can't just leave it to the regulators because the regulators are not moving. They're not doing anything, and they have essentially moved into a space where they are completely co-opted by the utilities.
Yeah, I would agree with that. I think in the rate of return, it's very transparent that the utilities have co-opted the regulators. I think the other interesting thing about the rate of return specifically as an issue is that the facts in the law are very clearly on the side, again, of the consumers and not on the side of the utilities and the regulators. And frankly, if you were to hold a hearing and focus on rate of return, it would literally be shooting ducks in a barrel, because it'd be very easy to bring evidence that's very compelling Has to be getting the regulatory record, but very easy where it is in the regulatory record to show like, hey, this is fundamentally flawed and broken, and it's costing consumers a lot of money. So I think from a political perspective, it's like an easy win. It's also very bipartisan. So, just from a political perspective, irrespective of the fact that, hey, the regulators need to be reined in because they're not doing their job, somebody needs to exercise some oversight. I think there's like, hey, this is a nice issue that I could, can garner a lot of support across, it's a very broad umbrella, right, of people who would want lower rates.
Thanks so much for that. And I do kind of want to ask Matt Casper if he might be interested in jumping in here and talking a little bit about intervener compensation and trying to make it a little bit easier for consumer advocates and others to participate in these kind of complex and really expensive processes at the regulatory commissions.
Thanks. Yeah, we're getting into the details of rate making and what's happening at the PUC level, or the ACC, and Mark hit on a good point of regulators have to rule and make orders of the evidence that is presented to them in the rate case dockets. And it's no surprise, of course, that the utility companies who are asking for hundreds of millions of dollars in rate hikes, wanting to get that higher ROE, are also spending millions of dollars on the economists, the engineers, the lawyers, the consultants to make those arguments to the regulators. And so it's a David versus Goliath fight. And I would point lawmakers to intervener compensation as one tool, and I'm glad it's highlighted in the report to rebalance kind of this situation that's playing out. This would allow nonprofit groups, other interveners to get status in the docket, and then get compensation so that they can have the money to hire staff, hire the experts to go and submit the arguments that Mark is calling for to be presented at the PUC level, because like we were all saying, the regulators need to act on what's in the docket. So groups like Citizens Utility Boards, the Utility Reform Network, these are groups that provide necessary information to regulators as part of their mission to keep bills affordable for residential customers, and intervener compensation plays an important role.
All right, thank you so much, Matt. Thank you to everyone who tuned in to watch today. Thank you so much to Senator Sundareshan. Thanks to my whole team here at AELP. You guys are all incredible. Again, we have our toolkit. It's out. It's available on our website. Also, if you want to get into the nitty-gritty on any of the things we talked about today, please email Megan. She will set you up. She will point you to the proper experts, get you plugged into state-level coalitions, advise you on the politicking around monopoly utilities. This is something I emphasize at the end of every one of these that we hold here at the American Economic Liberties Project. We're here to help folks at the state and local level work to hold their dominant corporations accountable. That includes monopoly utilities. So really, we're here for you. We're here as a resource. Please reach out, not just on the topic of utilities, but on anything having to do with corporate power and competition policy. We are available. It's literally our job to help make your lives easier, better, more effective, and to do good work for folks at the state and local level. Thank you so much again for tuning in, and we'll see you next time.